ignorance of law is no excuse in the eyes of law. Which means what? Which means that if you are non-compliant or non-ignorant, or shall I say not knowing about cyber law provisions, and tomorrow you are found to be violating, you can't take the stand that I did not know about the law. If you have violated the law, the consequences of law will have to follow, and you will have to be facing potential legal consequences, both civil as well as criminal. So therefore, whenever we use our devices, our communication devices, smartphones, tablets, phablets, laptops, PCs, we have to be fundamentally clear that we are connecting onto a public network. Whatever we are doing is leaving electronic footprints and traces, and those traces can be used against us by any legal entity in a court of law. This is so because all the legal format has been granted legality, legal sanction. So it's whether it's an email, whether it's SMS, whether it's MMS, whether it's any kind of electronic message, the same is legal and valid in a court of law. And of course, any person who wants to grind an axe against you can actually go ahead and try to use it in legal proceedings. So when we start talking about important cyber law tips when you do your day-to-day operations or business, there are various things that need to be looked into. First and foremost, you will have to realize that whatever you say on email, on chat, on live webinars, on the digital or mobile ecosystem could be used as legal evidence. So be very, very careful whenever you are starting your operations, whenever you are interacting with any person. Why? Because the other person is already a recipient. He has a copy of your digital communication. And should it be incriminating, should it be illegal, the same is likely to be used against you. Number two, whenever I'm doing a business or an operation, or I'm engaging in a negotiation with any party, today we invariably do it either through email or through phone. So email tends to get having records both in your inbox, in your email account or client, as also in the email account or the email client of the recipient. And today law legally recognizes the concept of electronic contract, which means a contract done through electronic means. You can exchange an email with another vendor or with another contracting party, and both of you agree to do a particular thing. That's legal contract. The law gives it legal sanction, legal validity. You can make it the basis for doing legal operations or even for purposes of planning your day-to-day stuff. Another thing, if you're doing a contract through phone, yes, that's also known as a mobile contract or a phone contract. But it's a verbal contract. But that does not really preclude it from it being legal. This is so because the contract laws clearly say that a contract can both be in writing as also in the oral format. And if it's an oral contract, it's a legally binding and enforceable contract. And in case there is a dispute tomorrow, you would be required to prove the factum that this kind of terms were agreed to you by both the parties on phone or on email. So this is the first thing when you start your startup operations, a business, that try to do your stuff online, try to keep a record of that online. It's easier, it's simpler, far more expedient, far more convenient, but more significantly, it's the speed and the convenience that it gives you that actually outweighs all other forms of physical world communication per se. Second thing that I think I need to tell you is that when you do your operations, you are getting email, you're sending email, please save them. Just don't disregard or delete emails at random. Why? Because in case the particular electronic communication is gone and tomorrow there's a dispute, you will have potential problems of trying to prove the said electronic communication. Third, whenever you're doing something online, you will require to have an online presence. So cyber law says that please protect your rights online. How do you do that? For a couple of things. Number one, you decide to start a venture, an activity. So what do? You zero down on a name. That's your name, your trade name on which you will actually be going ahead and doing your business online or even in the physical format. So the first thing, get a domain name. The domain name could be in any extension. Actually, domain names are nothing but identifiers of the internet protocol addresses. Idea is, it's very hard for people to know the technical address of your website. So you register a domain name. There are a large number of domain name extensions that are available. Top level domain names include .com, .net, .org, .biz, and then you have country code top level domains like .in, .us, .uk, .cn. So your choice, whichever you want to do, but please reserve as far as possible your names online. Why? Because domain names are given on a first come first served basis, and if you are not very quickly doing acts to get your domain name, the chances are that your domain name could be potentially cyber squatted about. And if that happens, then that could potentially impact your business activities, because somebody may use that domain name to divert traffic. So I want to come to your startup, your business, and I know your name, and I think that's going to be your domain name. So I type that, but effectively if that's not your domain name, I would be taken on to a different website. So the other guy could potentially be unauthorizedly or even illegally misusing legitimate web traffic that has to come to you. And that being so, it's very important that you should secure your domain name. It's also important to know that cyberspace is not a wild, wild west. It's not a place where law does not exist. Legal frameworks, legal mechanisms continue to be applicable to cyberspace. So all your trademark rights are equally applicable in cyberspace. So whatever is the name of your startup, if that name is the name on which you are doing your business, please also try to get a trademark registration. Get a domain name. These are exercises to not just identify your business with that particular name, but also to ensure that your trademark rights are adequately protected. World over, cyber law jurisprudence is crystal clear that domain names have to be accorded the same protection as trademarks. And therefore, if you have registered a trademark and you have a subsequent domain name based on the trademark, that effectively means that nobody else can try to copy that. If somebody does that, you can move proceedings under the Uniform Domain Name Dispute Resolution Policy for getting the concerned domain name back. So that's another important issue. We also believe that internet is a huge copying machine. In fact, according to some, internet is the biggest copying phenomenon in the history of human mankind. Well, that's correct, but that does not give you a complete, absolute, unbridled license to copy. There are still copyright rights and obligations and privileges which are available online. So if somebody is exactly copying the content of your website and is trying to monetize it or use it for commercial benefit, you can go after the concerned person, because you have got copyright in the content of your website that you've actually created. So do be very vigilant. Please do not take the copying of data or information from your website to be routine, and you should go after the concerned person, write him an email saying that he has actually copied your data and that you intend to take action. Normally speaking, people do not want to get into unnecessary legal problems, and they would remove the kind of information or data that they have actually copied from your particular website. And in case if they still are adamant, then I think legal action is the only route that's available. But once you are online, you suddenly are exposed to a variety of issues. One, of course, is whatever activity you do, whether it's e-commerce, whether it's m-commerce, you would be engaging with third parties, your customers, your vendors, your business partners, your clients. And therefore, you're required to have various norms to be followed. So just because you're online does not mean you will not follow the law. The law categorically says that when you do certain activities online, you come in the category of an intermediary. If you are providing a website, you become a website operator, maybe a website owner. Website is nothing but a service on a network. And that being so, it becomes a network service, and therefore you, as the website owner, become a network service provider. Similarly, if you are providing any other service online, you also get qualified in the capacity as an intermediary, which means that the law says if you are on behalf of another person dealing, handling or processing some records, you would be deemed to be an intermediary. Now the moment you are an intermediary, the cyber law says please have in place appropriate bare minimum compliances under the law. If you have them, that's great. That's going to actually be holding you in good stead, so that tomorrow there's a problem, you will not be potentially impacted because you're compliant with the law. But if you do not comply with the law, lo and behold, you cannot tomorrow cry and say the law is not helping me, because the law will not help you. They say the law only helps those who don't sleep on their rights, who are constantly awake and who are proactively complying with the terms of the law. So it's in your interest that you comply with the parameters of the law. It's at this point that I want to pause and see whether there's any question that any one of you have, and if so, I will be inclined to keep on taking your questions, and feel free to ask me any question on any cyber law tips that you will have. Well, we have a question, and this question is already from Ashish _Mr. Phone. Well, the question is very, very nice. It says if we add articles from various websites and also include the source from where it is taken in an Android application, does it come under cybercrime? Wow. That brings you to the bigger issue of cybercrime. Cybercrime is any activity done with an illegal intent or a criminal intent done online or using computers, computer systems, computer networks or computer resources, or even any kinds of communication devices. So a variety of cybercrimes exist, but in this particular case, when you add articles from various websites and you are actually giving a link of that website onto your platform or onto your website or even in the Android application, you are effectively acknowledging the fact that these articles are not written by you, are written by somebody else, and you're acknowledging that this particular person or this particular website is the source of the relevant website, relevant web article. That being so, you don't really commit a crime because you're not illegally or unauthorizedly copying. It's always nice that if you want to give a link, prior to giving a link, if you can just shoot an email saying that we are proposing to give a link to your article. If you have any objection, do let us know. You give that email, wait for a few hours and upload the article. By and large, people should not have a trouble or any problem if you are going to be linking on to their articles. Effectively, it's mutually beneficial. It will help their articles to get more publicity. More significantly, the moment you are acknowledging them and saying that these articles are authored by a particular website or a particular author, you are crystal clearly saying that you are not the person who is author of the same, and therefore that will be well within the legitimate ambit of fair use under the copyright laws in the available national legal jurisprudence. However, it's always a good idea also to give a small disclaimer on your website or on your Android application saying that we are linking articles from various websites or various authors. The copyright in the said web articles belongs to the respective copyright owners, and you disclaim any liability for the same. So by that stretch and by that language, you're effectively telling the entire world that you are not the author of the same, somebody else is the author and you're merely linking it. That will come within the legitimate ambit of fair use and is something that can be legally done. There's no cybercrime that you commit. But yes, if you do cut and paste of somebody else's article and then you put it on your website under your name, or you do not put it even under your name but just do a cut and paste without giving an acknowledgement, then there is a problem, because then it will tantamount to violating somebody's copyright. There is not even any acknowledgement. So, or some people are even brazenly adventurous. They go ahead and cut and paste somebody's article, put it on their own website and say that this article is written by me. Now that's something that the law is not willing to be lenient about. Not only is that copyright infringement, but the same also is a cybercrime, because you are ultimately doing activities dishonestly or fraudulently that are aimed to diminish the value or utility of any electronic information, including any original electronic articles or web articles that you could think of. So please link, please give the acknowledgement to the relevant sources of either the website or the author and go forward. There's nothing to be bothered about. It's much more nicer if you give a small note or disclaimer on your website saying that whatever the linked articles are, the copyright for the same belongs to the respective copyright owners. With that, I think things are perfectly fine. I see some more questions coming up. Okay. Here is a question from user Grana_Frisco. It says, can the concept of a website and business rules be copyrighted? That is a very nice question because that impacts almost everybody who wants to do business online. So the scenario is, here is what we come with the concept of copyright. What is a copyright? Copyright is the right in a copy. Well, when you actually author an original, literary, artistic, cinematographic, dramatic or musical work, the law says you have got intrinsic copyright in the same. That effectively means that no one else can copy the same. If somebody else copies the same, that would be in violation of the law. So you are given intrinsic copyright the moment you author an original literary, artistic, musical, dramatic or cinematographic work. Now that effectively means what? Your work must be in some concrete form. Merely because I have some idea here in my mind, that itself is not amenable to copyright protection because that's in an intangible form. The moment I reproduce that idea on a piece of paper or on an electronic record, that becomes an original literary work because I've actually applied my own thoughts, my own intellectual inputs, and have thereafter drafted the said idea in the form of a document, a note, or even a noting. Now you've got copyright in the same. So it's very important that when you talk about issues pertaining to concept of a website, if the concept of the website is in your brain, it's not amenable to copyright protection. But if you reproduce the concept of the website on paper or on a Word document or in the physical world format, you get intrinsic copyright in the said document because the said document then becomes an original literary work. Why? Because the way you are going to plan writing the document, the kind of features you will have for the website, the kind of language that you will use for the purposes of expressing the intrinsic elements of the website. This will be something unique only to you and your style. Nobody else in the world will be able to do so. And therefore, you will have the copyright in the same, and therefore you will also be well entitled to ensure that nobody else copies it. If somebody else copies it, you can request him, you can ask him to pull that particular content down, and he's duty bound to do so. And if he does not do so, you can go to court of law and get injunction against the said person from infringing your copyright. The second question that was asked for, do we have copyright in respect of business rules? Again, the idea is very clear. If the business rules are in the mind, there's no copyright. But if you reproduce those business rules into writing, into concrete format, that becomes an original literary work. That being so, it is amenable to copyright protection. You can also say, well, I don't want to write it. How about recording my business rules through speech? No problem. You do a digital recording. That becomes an original audio, and therefore is again an original work within the meaning of the Copyright Act, and that is also amenable to copyright protection. So please document and write your business rules so that your business rules can then be protected by copyright. The question that will be coming to your mind will be, how long is this copyright valid for? Typically speaking, if you are the author of an original literary, dramatic, musical or cinematographic work, or even a photographic work, the copyright in the same is for a particular period of time. And that period of time is up to your lifetime, for however long you live, plus 60 years after your life. So you can actually protect your work during the entire tenure of your life, and also for a period of 60 years after you're dead and gone, and that's a kind of protection that your legal heirs, your representatives and your other people who succeed to your interests will be able to have. So please document your stuff without any hesitation, without any fear, and the law says you have got copyright in the same the moment you author the same. There's There's a concept of registration of copyright. A lot of people say, well, I must get my copyright registered. Well, yes, it's possible. You can go to the registrar of copyrights and get your copyright registered. Absolutely fine. But registration of copyright is not mandatory. The law says you got copyright the moment you author the original work. That's right. The moment you author it, the concept of copyright comes into existence. The registration is normally only said because it gives you proof of the fact that you got copyright. Because once you apply for a registration with a governmental authority, say the registrar of trade of copyrights, then in that case, and the government gives you a certificate of copyright registration, that's a kind of an evidence of the fact that you have got copyright in the same. Otherwise, if you don't have that evidence, it will be upon you to prove that you had authored the concerned document at the relevant date and the relevant time. I go on to the next question, and the next question is, and this is by the user Aditya _ all to get. The question says, for a global website, can regional, within bracket country cyber laws, will still come into picture? The answer is a crystal clear yes. Why? Because when you do a global website, it's targeted to the entire world. It's exposed to the entire world, so it gets exposed to a variety of legal frameworks. First and foremost, it gets exposed to your local national laws. Why? Because your website ultimately will, well, your website would also be seen to be in violation of that country's cyber law. And technically speaking, even action can be taken against the website. For example, some countries have laws which prohibit a particular kind of content. Now, you may be located in one country where that content is legal, but the target country where the website is visible may be a country where your kind of content may not be allowed or may be banned. In a scenario like this, your website is not only going to be governed by a country's national laws, but will also be governed by the target jurisdiction laws. So you will have to be very careful. Therefore, they always say, please have in place detailed terms and conditions, which categorically say what's your legal stand on the content that you're providing, which kind of law will be applicable. So you must insist that our website is in a particular jurisdiction. We will be governed by that jurisdiction. And the moment a user accesses my website, he agrees to the fact that any action or any acts done in respect to the website will be governed by the respective national legal frameworks of the place where you're located. That certainly helps you to get more legal protection. But technically, national laws apply to all regional or even international websites per se. Well, I'm going on to the next question, and the next question I'm seeing is from the user Bharat _ advital. Bharat _ advital says, how to reduce the liability of content in terms of claim and scientific studies. Is disclaimer enough, or do we need any other policy or documents or websites studying the same? That is a $1 million question. You need to be very careful of the kind of content you put up online, because the kind of content you put up online will determine the kind of compliances that you will be required to be doing. But if you are in India, you have to quickly realize that you get governed by the Indian cyber law. The Indian cyber law is the Information Technology Act 2000. I want to give you a quick update. The IT Act was enacted in the year 2000 in India for a limited purpose. They wanted to promote e-commerce in the country. They wanted to give legality to the electronic format. And more significantly, they also wanted to amend certain laws of the country, being the Indian Penal Code, the Indian Evidence Act, the Bankers' Books Evidence Act, and the Reserve Bank of India. Now, this law got amended in the year 2008, and now various compliance requirements have been put in. So in respect to your question, you have to quickly realize that when you provide content online on a website, you become an intermediary. You become a network service provider. That being so, under Section 79 of the Information Technology Act 2000, you as an intermediary are required to exercise due diligence while you discharge your duties and obligations under the law. That being so, there are certain compliance requirements. For example, the law says please have in place terms and conditions for your website. Have in place your rules and regulations. Have in place privacy policies. And more significantly, have in place a user agreement that actually informs the users what kind of activities they can do or not do, what kind of content they can upload or not upload, post, publish, transmit or relay using the computer platform of your particular website. So please have in place appropriate terms and conditions. You can reduce your liability if your terms and conditions are crystal clear and tell the normal lay users of what kind of content you are uploading, what is the nature of authorship of the content, what is the source of the said content, what's your role as a website when you are making the said content available, what kind of due diligence you have done to ensure that the said content, including content of scientific studies, is made available. As far as possible, we should be very clear. If I am giving content to which the rights belong to me, things are absolutely fine. Why? Because that's my original content. I am well within my rights to give the same. But if I am giving somebody else's content, I need to be sure that I must give appropriate acknowledgement to the concerned author or the concerned copyright holder in the said content. Further, if your website is such that's allowing users to come in and interact, to upload, host, post comments, criticisms or whatever third-party data you think of, then the law says please have in place more terms and conditions which should actually stipulate your users what they can and what they cannot do on your particular platform. For example, users, they can come to your website, but they cannot use your website for purposes of uploading, hosting, forwarding, publishing or retransmitting content that is violative of the law of the land, or say that's obscene, that's lascivious, pornographic, or that appeals to the prurient interest, or something which is, say, against the sovereignty, integrity, security of the country, or something which violates the copyright or other intellectual property rights or trademarks of another person. So you must, through these terms and conditions, inform your users, please come to my website, look at my content, you want to upload your comments, please do so, but please don't do any activities which are not permitted under the law. Once you give these terms and conditions and ask the users to accept the same, some people say, well, the moment they come to your website, the very fact that they are visiting your website, they read your terms and conditions. Some people take specific consent of the said website, terms and conditions, but whatever you do, once you have this in place, then you have effectively taken step to limit your own liability as a network service provider. Because you've told the people, this is what all you can do, this is what you can't do on your website. And if after these said terms and conditions are available on your website, somebody still goes ahead and violates the same or contravenes the law, then the law says, I'm not going to catch hold of you, because as a website owner or an intermediary, you've already done your due diligence. But the concerned person who's violated the law, then the law is going to go after them. So please ensure that have these minimum parameters of terms and conditions, rules and regulations, user agreements, privacy policies and disclaimers in place when you're uploading content on these websites, because that will help you to be on the right side of the law. Because you cannot and can never predict what kind of a content or kind of response mechanisms or comments are going to be actually published on a website by users. And supposing that's something that's in violation of the law and you haven't got your terms and conditions in place, then the law is very clear. You will be as much as guilty as the concerned party who has published the said offending content of various contraventions under the law. And of course, appropriate action can be taken by any affected person, even by the state, in case, depending on the nature or the previous element of your contraventions or violations. So, be on the right side of the law, ensure compliance with law, and I think you're pretty much good to go. Don't be bothered about other people suing you, because the law says, well, number one, ignorance of law is no excuse in the eyes of law. Number two, the law says if you comply with me and my terms, I will make sure that no harm will befall upon you. Which means that once you comply with the law, then people can sue you. People can file criminal complaint against you. but you cannot be forced to pay one single rupee or one single dollar or cent as damages. Number two, no criminal prosecution, no criminal consequences will visit upon you. So therefore, the idea is very clear. The law says comply with me and forget about other things. Therefore, as legitimate people who are doing startup activities or doing activities online, please ensure compliance with cyber law in your respective operations, and to that extent, I think you will be well on course for being protected from any exposure to third-party data or liability for the same in the coming times. Well, I see some more questions coming in, and let me go on to the next question. Well, here is a question from the user Ronak_BMF, who says, please suggest what are the recommended certification for cyber law for a beginner. Well, cyber law, as I said, is not a law only for cyber lawyers or for lawyers. It's a law for every user in the digital ecosystem. Any stakeholder in the mobile environment which is using the digital space, it needs to be concerned about cyber law. So in that context, you have asked me what are the specific certifications for cyber law. First and foremost, there are no minimum certifications required. The cyber law only says that you need to go through my terms, ensure that you comply with my provisions. Of course, some normal courses are available. There are some private courses which allow you to do an online diploma or an online program which sensitizes you about cyber law frameworks or principles. I will encourage any of those courses which are available online can be done. A lot of them are free courses, a lot of them are paid courses. You can do your stuff, your own research online, see what exactly you want to do. But of course, if you're looking for a more serious approach, then there are some courses online which give you more detailed frameworks and principles. There are some massive open online courses available, you can go to them. There are some universities which are providing for online certifications and online diploma programs. You can do that. For example, in India, there's a university known as Nalsar in Hyderabad. They have an online course on cyber law. That's a pretty good course for a beginner. You also have courses by the Indian Law Institute. You have a variety of other universities now coming up with cyber law diplomas and programs. So it depends on what exactly you would want. Look what suits you. There are some private courses also available, and go ahead and do so. I'll actively encourage you to also try using some of these massive open online courses, because they are free, they give you a lot of exposure, and they make you understand about what the nuances of cyber law are. Well, I go on to the next question. Of course, in terms of recommended certifications, let me pause and give you another perspective. Well, the laws, one is a certification that you will need to do as a beginner, and so these online diplomas can be good, or the online training programs can be good. But the law itself says that if you are handling or processing sensitive personal data, then you must at least follow a minimum certification. And the minimum certification that the Indian cyber law has prescribed, for example, is an ISO 27001, which is the international standard for information security. So the law does not say please have a certification. The law says at least comply with the underlying principles which are governing the ISO 27001 certification. So if you're talking about certifications to be complied with under the law, then I think these kind of certifications could also be good. In addition, there are a large number of books that are available. A lot of them are available online. I've written various of these books that are available online. They're also available on Amazon. You could read some of them and to have a more detailed exposure about relevant aspects of cyber law per se. Of course, there are some lot of books available that I can see at my back, but those are not for beginners. Those are for people who want to go more detailed into various aspects of cyber law per se. I now go on to my next question, which is okay, I can now see the next question. This next question I'm seeing is, this question again comes from Aditya _all to get. He says he'll continue with his question that if the global site mentions in terms and conditions that will be governed by parent country's cyber laws, will regional cyber laws will still be compliable? Well, typically if a website says I'm governed by particular terms and conditions and by a particular country's laws, then by and large, if the matter goes to court of law, the court of law will say because it says it's applicable by those countries' laws, then the relevant standards of that country's laws would be applicable. But this is not to say that regional cyber laws won't apply. Supposing your website is in violation with regional cyber laws, in that scenario, then it can always even be argued that the regional cyber laws would also be applicable to your particular web operations. But I think there are no golden formulas. Each case to its own facts. It is dependent on the specific nature of information that you are actually wanting to upload and host as also transmit using the website per se. There's a question from Anirut_Zobrand who says we are contest aggregator website. If our company is mentioning credit source with disclaimer, do I still require copyright permission? You are a contest aggregator website. You are aggregating content pertaining to contests. So when you are aggregating content and you're giving credit source with the disclaimer, that I think is good enough. But clearly, if you give an email to them, that will even help them even more better. Because the scenario is that it puts you in the sense of double protection. In fact, when you talk of double protection, if you only put disclaimer and you say sorry, I am fully governed by the law, that may not be totally correct. Tomorrow the guy can still say, well, you have put your disclaimer, where did I authorize you to actually go ahead and use my content on your website? Now if it is more so if you are a contest aggregator site and you are monetizing content belonging to the aggregated content, there could always be a challenge. The guys could say, well, your mere disclaimer won't suffice. Where did you get my permission before you actually went ahead and uploaded content? And in a scenario like this, therefore it becomes critical that sending an email becomes very relevant. Send an email asking for permission, wait for 5-6 hours. Ideally I say wait for 24 hours before you start uploading the content. If you do that and there's no response, please upload the content. And if a person doesn't respond in 24 hours, the presumption is that he has no objection to the use or uploading of content on your website. But in case there's somebody putting up any objection, then I think it will be better that you at least remove that particular content to which the objection has come. Because tomorrow, if you don't remove that, there can always be some problem or the other and the guy can sue you. Please understand, as a contest aggregator site, you are an intermediary. Please ensure that you comply with the requirements of documented due diligence that's there under the information technology law in India per se. If you don't do that, a lot of people don't do that, so you will not be wrong. What happens? That's one question that a lot of people ask me. Well, a lot of things can happen. First and foremost, a lot of Indian people specifically subscribe to an Indian school of management known as the Indian Jugaad School of Management. They like to just quick fix some things, do some jugaad and do going about things. My suggestion is your Indian Jugaad School of Management normally would not be coming to your aid or benefit the moment if you do not comply with the law. Number two, if you don't comply with the law, there are two kinds of consequences that you need to be aware of. Number one, you can be sued for damages by way of compensation up to 50 million rupees per contravention under the Indian cyber law, for example. So, per contravention, if you're prepared to be sued for 50 million rupees or 5 crore rupees, by all stretch, go ahead, don't comply with the law. But if you don't want to do that, please comply with the law. The second consequence for non-compliance is that you could potentially even be exposed to criminal liability. Your top management, if you're a company, or if you're an individual, you per se, could be exposed to potential criminal exposure. A criminal case could be registered against you. And in that case, maybe legal action can be taken against you, could be sent to jail, and you could even be saddled with fine and other undesirable criminal consequences. So be on the right side of the law. That will help you to ensure compliance with the relevant parameters of law. I now go on to the next website and the next question that we have. Okay. Is that cyber laws come under the control of antivirus companies or Indian CERT? No. Cyber law does not come under the control of anyone. On the contrary, cyber law creates statutory authorities. For example, the Indian CERT or the Indian Computer Emergency Response Team is actually a creation of the Indian cyber law. That's a statutory authority that has been created under the Information Technology Act 2000. Similarly, if you think cyber laws are governed your question is cyber laws coming under the control of antivirus companies? By no stretch of imagination, no. Cyber law does not come under the control of antivirus companies, but yes, antivirus companies come under the control, ambit and applicability of cyber law per se. So, if you're an antivirus company, because you're providing these services, you still come within the ambit of cyber law per se. I go on to the next question that's coming up. After completing the certification, what are the various career opportunities and profiles in cyber law? That's a question from Ronak_BMF. Well, Ronak, there are a large number of opportunities available for you when you do cyber law. Why? Because today cyber law is required to be done by almost anyone. Today almost all legal entities require people who could advise them on cyber law. So you could go in as part of an in-house advisor, an in-house counsel, maybe you can do an independent practice, you can be a consultant, you can go into any field, and there are so many now new fields coming in. For example, cyber security is now becoming as a big field. So a lot of companies would want more information on how to comply with, say, cyber security compliances. You could assist them in that. You can get employment in any corporate company. Today, companies are looking at multi-skilling. So they would not only want to hire normal people, or normal technical people, or normal lawyers. They would want people to have multiple skills so that they can actually get benefit of the diverse exposure and experience. So there are a lot of opportunities for you if you do cyber law, and endless opportunities is all I can say. The world is moving towards a digital format. Everything is coming out here. So therefore, there will be trouble, there will be legal problems, legal policy and regulatory issues will abound. And in those scenarios, there will be need for far more number of people. So there's very bright career opportunities for you if you do cyber law as a career. I go on to the next question. This question is coming from what kind of cyber laws, what kind of cyber laws are applicable to e-commerce business? This is a question from Parul_personal. Well, today if you are doing e-commerce, Parul, your activities would be governed by cyber law. Now, which is the cyber law? This is the Indian Information Technology Act 2000. When you do e-commerce, you're providing your services on an e-commerce platform. That means so, you become not just a content provider, you become maybe a web service provider, you become a network service provider, ultimately you become an intermediary. So once you do that, in terms of providing e-commerce or e-business, you are required and mandated under the Indian cyber law to do various compliances. I've talked of some of these. For example, you have to have in place the terms and conditions, you need to have your rules and regulations, your user agreements, your privacy policies, and disclaimers, some common minimum parameters that you need to comply with. In addition, when you are doing e-commerce business, you would ultimately also be dealing with a lot of client information. You will be handling, dealing or processing sensitive personal data. Maybe you will also be dealing with credit card information, financial records, maybe even biometric records, maybe medical records. Well, today there's increasing use of Aadhaar now happening work is going on of how we can even try to marry Aadhaar and go on for connecting into mobile payments. So in a scenario like this, there will be some additional requirements of compliances that the Indian cyber law needs to do, specifically when you are dealing, handling or processing sensitive personal data. You need to get the consent of the users, you need to retain documents in a proper format, you need to ensure that the cyber security of the concerned relevant electronic records is appropriately protected. You are required and mandated to actually implement and maintain reasonable security practices and procedures when you actually go ahead and deal or handle this sensitive personal data. So there are a large number of these compliance requirements. So cyber law totally applies to e-commerce websites. Please ensure whatever e-commerce transaction that you are doing in, please ensure that your transactions, your operations are complying with the requirements of law per se, specifically the cyber law. And you have to quickly realize that the Indian cyber law is a special legislation. For example, Section 81 of the Information Technology Act 2000 says that the Indian cyber law is a special law and the provisions of the same prevail over anything inconsistent therewith contained in any other law for the time being enforced. So effectively, in a common man's language, if there is anywhere a conflict between the Indian cyber law and any other law, the provisions of Indian cyber law shall supersede and prevail over anything inconsistent therewith contained in any other law for the time being enforced. So please, if you are into the e-commerce space or e-business place, please ensure compliance with law on cyber law. You see, people think that they can be adventurous, but somehow in the context of e-commerce or e-business, adventurism may invariably never help you. If you are non-compliant with the law, today, tomorrow, day after, the chances are you could come and be stuck in a bigger mess, a bigger whirlpool, from where not only it's going to take you a large amount of time to get out, but also that the same will entail large number of reputational risks to your reputation and your goodwill and repute. So I think totality-wise, it makes far more sense that your operations comply with cyber law per se. Okay, I am seeing there is more questions. Okay, there's another question. How can we connect with you for spreading more and more cyber awareness in the country? The question comes from Sagar_IT culture. Well, Sagar, please feel to connect with me. I've been working in the space of cyber law for almost 2 decades. I have been seeing that this is one space where more and more capacity building is required. So we require more hands, more volunteers, more people who can get committed into this. So if you're interested in creating more cyber awareness, please connect with me. I will share with you at the end of the webinar, but even right away, my email address. My email address is very simple. My website is pavanduggal.com, PAVANDUGGAL.com. You can connect me on my Twitter handle, which is @Pavan Duggal, PAVANDUGGAL. My email is very simple. It's Pavan, PAVAN, @pavanduggal.com, PAVANDUGGAL.com. In addition, if you want a Gmail address, it's pduggal@gmail.com, pduggal@gmail.com. You can connect up to me. There are a lot of variety of initiatives that we are doing, and we'll be happy to connect up with you. Also, I would want to point out to you that every year we do a big conference on cyber law. This is the International Conference on Cyber Law, Cybercrime and Cyber Security. We do that every year. TIE has been a supporter of the said event for a number of years. This year we will be doing that event as a 2-day event on 17th and 18th of November 2016 in New Delhi. So if you want to get connected with us and with that event, we'll be happy to have you and have your inputs. I can tell you the capacity building space is a space which is scarce for resources, for concerned, conscientious people. And therefore, if you would want to contribute, we'll be more than happy to rely upon you for creating more cyber awareness across the world and across the country per se. I see more questions coming up now. Okay, let me now see. Wow. Vartika underscore ask leg has a very pertinent question. She says, sir, referring to the electronic contracts you mentioned earlier, which are legal, is digital signature mandatory for making contracts / agreements enforceable, or we can ignore it? Fabulous question, Vartika. Why? Because I think this is one question that is in everybody's mind. Digital signatures have become more and more prevalent in the last 5-6 years. Well, if you are earning beyond a particular limit, you have to now sign by means of digital signatures your income tax returns. If you have to engage with a register of companies, the ROC under the MCA 21 is now only dealing with electronic format and is only using digital signatures. So the question is digital signatures mandatory for electronic records or electronic contracts? First, electronic contract is legal. Why? Because the contract can be in writing, it can be on oral. In this case, your electronic contract is going to be in writing. This would be legal and valid under the Contract Act and the Information Technology Act. Does your contract, your email contract or e-contract needs to be digitally signed? My answer is a crystal clear no. Why? Because the law does not require a contract to be signed. If you sign it, that's even nicer, because that gives you added proof of the fact that some person by this particular identity has put his digital signatures and he's accepted the terms and conditions there. But if you don't even append your digital signatures, that does not mean that your electronic contract does not become legal. It's still legal. Of course, the onus will be upon you to prove that this is the electronic contract that was so entered into by the parties. But if you put your digital signatures on the electronic contract, then I think your electronic contract becomes on a far higher pedestal in terms of the authenticity, in terms of its reliance. Because once a document or once a contract is digitally signed, then a party cannot resign from the same. And a presumption is given that the said person has put his digital signatures in a conscious, careful and free mind, so that tomorrow he cannot resign from the terms of the same. So if you can get a digital signature on your e-contract, better. That will enhance the authenticity and veracity of the contract and will be putting you on a much more stronger legal wicket. But even if you do not have digital signatures, don't worry. The law says even without digital signatures, an electronic contract is legal, valid and has been given legal sanction as per the law, both under the Information Technology Act 2000 as also under the Indian Contract Act. I now go on. I also wanted to mention one more thing. Under the IT Act, they have now come up with a specific provision, section 10A, which categorically says that just because a contract is entered into using electronic means, it is not going to be discriminated against in any manner whatsoever. So that effectively means that your electronic contract is legal, valid, and the IT Act does not really even mandate you to have digital signatures on your electronic contract. With that, I hopefully should answer your question. I now will give you my answer to the next question. Well, there's so much activity happening. I'm just trying to find out where did we last leave. Okay. Wow. There's another question by our friend online, Anirudh_Jogrando, who says, if a company launches a poker website, what legal compliances need to be followed? Well, if you launch a poker website, you become an intermediary. Please ensure having your terms and conditions in place is critical. Have your documented due diligence. Have your rules and regulations for people how they will be using poker. And also, you will have to be careful of this entire space as to what's a game of skill versus game of chance. Because at the end of the day, you'll have to realize that the Indian law makes a distinction between game of chance versus game of skill. And to the extent that the same is a game of skill, you're well within the ambit of the law. The moment you start going into game of chances, there are potential ramifications which you need to be careful of. So please ensure have your specific privacy policies, have your terms and conditions. You must be ensuring that in your terms and conditions you are saying how your operations are compliant with the law, so that any person, any user who comes to your website or for your business is at least having this basic kind of a satisfaction that you are compliant with the provisions of law per se. In addition, please ensure that if you are handling, dealing or processing sensitive personal data, get your other compliances under the Information Technology Act in place. You must also realize that, when you are doing this poker business online, you would also be governed by various rules and regulations that are already enacted under the Information Technology Act. Primarily, these are some of them include the Information Technology Intermediary Guidelines Rules 2011 and the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data and Information Rules 2011. Please ensure that your businesses are compliant with that, with these particular provisions of the IT Act and rules, and then you are on a safer wicket. But be prepared, there could always be potential legal exposure. Somebody could always come up and sue you. So you must have a backup plan, that in case if you tend to get sued, what will be your specific defense requirements or your strategies. I will suggest that as a poker website, please ensure that you comply with the mandatory requirements required for intermediaries under the IT Act. And then say, well, I have come under the statutory provision of protection granted to intermediaries. Why? Because if I have complied all the compliances under the Indian cyber law as an intermediary, then the law says you as an intermediary cannot be held responsible. The law gives you a statutory exit from liability for any third-party data. And I think you should purely rely upon that particular space in order to limit your exposure to potential legal liability for any third-party data or information. I hope that would answer your question. I have another question here. Well, here's a question by friend Nandita_Semko. Says, sir, can you provide recording of this webinar? And it's very helpful, and I would like to hear this again. Thanks for your comments and inputs, highly appreciated. I will be happy to do so, and I'll request Ty, the organizers of this webinar, to make a copy or a recording of this and maybe host it on their website and send you links where you can download the same. Because these are issues, I'm learning by your questions. The more you're asking, the more I'm not only answering, but I'm also applying my mind and saying, okay, this is how we will apply cyber law. You see, we'll have to quickly realize that cyber law doesn't have golden principles. You will have to be seeing how the provisions of law will be specifically applicable to you for your specific startup, for your specific operation, for your specific business, and for your specific setup. So therefore, while I can talk of broad generic principles, but whenever there are specific questions, they actually help me to also give you specific answers per se. So I will request Ty to make a recording of this and be made available on the website so that anyone can actually download the same. Okay, there is now another question that I am beginning to see here on my line. Okay, and I think this is a question very interesting. Abhilash_sail-free says, what all laws prevail in terms of privacy of a user's data? If an app accesses my pictures, videos, SMSs and uses it for its own use, is it legal? One big question everybody is concerned about, our privacy. We are all looking and we are living in a world of a paradox. We want more and more privacy, both personal privacy and data privacy. And yet at the same time we find that privacy is a paradox. It's an anomaly. A lot of people say that privacy does not even exist in the online space. So in terms of this, nonetheless, we still find that different countries have in place appropriate national legal frameworks and provisions for privacy, data privacy and personal privacy. Some countries are much more advanced, some countries are less advanced. So today in terms of privacy protection, the European Union is one of the most well advanced jurisdictions because they have immense focus on data protection and data privacy as also personal privacy per se. If you talk of US, there's a focus on privacy, but if you look at the developments in the last decade and a half, after the 9/11 World Trade Center attacks, we've seen a dramatic erosion of privacy laws in the US. Today, more and more laws in the US are actually saying that in the event of a conflict between your privacy and national security or national interest, your national interest of the countries will prevail, and therefore privacy will have to play a second fiddle. But when you now come in the context of a country like India, you have to be alive to the fact that India does not have any dedicated law on privacy in place. We only have the Information Technology Act 2000, and that has got some elements pertaining to privacy. But unfortunately, those elements are not enough. For example, it talks about some elements of data privacy, some elements of personal privacy. And personal privacy, I think the law's approach and perspective is pretty primitive. For example, the law only considers your personal privacy to be invaded if somebody captures the images of the private parts of a particular person. I think that's a very, very prehistoric way of looking at personal privacy. Today, personal privacy means all the personal space around you. I am, as a person, entitled to my personal space. Of course, if I'm not doing any violation of any law, I'm entitled to protection of the same. But yes, the law enforcement agencies also have rights to pierce to your privacy in case if you are violating or you're doing any action which is in contravention of national interest, national security, sovereignty, or the national laws per se. So in this particular case, your question is, the normal law that will be applicable for you will be the Information Technology Act. When the app is being downloaded by you, the law expects you to do some due diligence. Please read the terms and conditions of the mobile app before you download the same. And unfortunately, all of us, almost 99% of us, do not even read the terms and conditions of WhatsApp. Of not just WhatsApp, of any mobile application. We quickly download it, we quickly tick on I accept without even thinking, reading, or understanding the ramifications, and we go ahead. And we quickly need to realize that today a majority of these mobile applications are data hungry applications. These guys, once you download them on your mobile, they go and attack your address book. A lot of them attack your photographs, your SMSs, and all those things are set in those terms and conditions. So if you read those terms and conditions, then at least you would be more in a well-intelligent position to take an intelligent decision whether you would want to download the website, the mobile application or not. But if you have not read the terms and conditions, and if you have accepted the same blindfoldedly, and then you find that the mobile application has misused your data, there's nothing much that you can do. Because at best, you can try to sue the said mobile application service provider, but the mobile application service provider will say, sir, I put all my cards on the table. All my terms and conditions were there. If you did not read it, that's your funeral. And the law, unfortunately, is going to side with the side of the mobile app service provider. So be careful before you start downloading a particular mobile application. But if you still find that the mobile application terms and conditions don't talk of a particular access to your photographs or your personal records, and they're still cheating you and unauthorizedly accessing, then it's a case that's made out both for a cybercrime under the Indian IT Act. In addition, you can also sue the said mobile application service provider for damages by way of compensation. You can also get injunction against them. But due diligence is the only mantra, is the only thing that you have to be careful of when you do work. Because the more careful you are about your privacy, the more secure your privacy is going to be. So the more duly diligent you will be in terms of downloading the kind of mobile applications, the better I think it's going to be for you, for your data protection, for your data and personal privacy per se. Well, I will go on to the next site, the next question. Wow, this is a great question coming from Nandita_Senko. Are white hat hackers, ethical hackers, protected under cyber laws to a certain extent as they breach certain cyber rules while executing their jobs? Nandita, the law unfortunately does not use the word ethical hacker. Earlier in the law in the year 2000 made hacking a crime that was made punishable with 3 years imprisonment and 5 lakh rupees fine, or 2 lakh rupees fine then, and the fine got extended to 5 lakhs in 2008. But the law does not use the word ethical hackers. In fact, the law says hacking takes place the moment you access somebody's computer system without that particular person's consent or permission. In this particular case, when you are an ethical hacker, you're obviously entering into somebody else's system without his permission. If you're doing so, then you are in compliance with the law of cyber law and no action can be taken against you, provided that you have at least the permission of the concerned person in writing. That must be in a documented form, so that once you have the documented permission to enter into a computer system, a computer network, that's fine. Then your activities are legal because you're doing it with the permission of the person. But if you don't do it with the permission of the person, and you just do it with an intention that I'm an ethical hacker, my intention is noble and I will hack inside to find about security vulnerabilities, then I will want to warn you. Why? Because the law is not bothered about your intention. The law says the moment you unauthorizedly access somebody's computer system or network or his website, you have committed a computer-related offences, and that is a punishable offence which gets punished under Section 66 and Section 43 of the Information Technology Act 2000, gets you 3 years jail time, 5 lakh rupees fine. So be very careful. A lot of times you find these wordings by ethical hacker or hacking institutions who give you ethical hacking courses. I will encourage you to be understanding the ramifications of hacking, because hacking is an offence under the law. And I will encourage you not to do any activity without the written permission or consent of the concerned person who is the owner of the said particular computer resource. With that, I think if you are having that broad perspective in mind, you can be ensuring that your activities are compliant with the provisions of cyber law per se. Okay, here's a question from Arinut underscore Zobrando. He says, and Abhishek, hi, could you please provide the number? We will, I'm told we're going to provide you a number where you can connect it with us. I'll also give you my numbers at the end so that at least any input you require from me in terms of cyber law, I'll be more than happy to do so. There's also a question from Prakash. Okay, Prakash underscore Monday says, ransomware attacks are robbing of valuable data. Is there any provision to catch these criminals under cyber law? Answer is yes. Ransomware is not mentioned under cyber law, but typically when ransomware happens or is executed, you are dishonestly or fraudulently doing an activity which is aiming to diminish the value or utility of electronic information residing in a computer source. Now that becomes an offence under Section 66, read with Section 43I of the Information Technology Act 2000, if you do the same dishonestly as well as fraudulently. Well, considering the fact that ransomware is always a dishonest or a fraudulent activity, ransomware can be brought within the ambit of computer-related offences under Section 66, read with Section 43 of the Information Technology Act 2000. That, of course, gets you 3 years jail time, 5 lakh rupees fine. But unfortunately, because a lot of the law enforcement officers are not clued up of how to interpret the cyber law on ransomware issues, we often find that a number of cases of ransomware do not tend to get registered under the Indian cyber law, but tend to get registered as Indian Penal Code offences. Well, we'll have to quickly realize that we will need to create more capacity building. But having said that, I am, as a student of cyber law, not happy with the way Indian cyber law's position is on ransomware. And forget about ransomware for the general position of Indian cyber law on cybercrime per se. Why? Because the 2008 amendments had seen India doing a historical blunder. India, by virtue of amending the IT Act in 2008, made a mistake for which we are all suffering till now. We made almost all cyber crimes, barring a few cyber crimes, as bailable offences, which meant that the cyber criminal was entitled to bail as a matter of right, which effectively meant that the moment the guy is going to come out on getting mail, the first thing that he will do will be to go ahead and delete the relevant incriminating electronic evidence against his own self, and then the chances of getting a conviction in these cybercrime matters virtually dries down to naught or to complete zero. So that's the reason why we've seen complete drought of cybercrime convictions in the country per se. I personally believe the time has come that India must have a dedicated legal provision on ransomware. Why? Because ransomware is a very, very dangerous offense. Already various predictions have said that ransomware will continue to grow at unprecedented lengths in the year 2016. In such a scenario, India requires a distinct legal provision which tackles with the specific offense of ransomware. Further, we need to make ransomware punishable with minimum 10 years imprisonment and fine of minimum $2 million rupees or more. Why? Because somewhere down the line we would require to put deterrence in the minds of the people who are engaging in ransomware. I have done some cases for some clients whose business operations have been prejudicially impacted because ransomware was targeted at the computer systems and networks. And I also will tell you that some clients didn't know what to do. So some of them even landed up paying some money. But having said that, you need to create a deterrence for those guys who are now using ransomware as a platform for engaging in more cybercriminal activity. And for that, I think there's an urgent, immediate requirement for Indian cyber law to be amended in this regard per se. Now this is a question from another user, Adi_OL. How much time frame is provided for removing the controversial content after the reporting? The time that's required for removing is 36 hours after reporting. Now that's what the Indian rules under the Indian cyber law say. Well, you specifically if you refer to the Information Technology Intermediary Guidelines Rules 2011, they say if you're an intermediary and once it comes to your actual knowledge that there's some offending content on your network or some affected person notifies you or a government agency notifies you, then you are required to act and take action within 36 hours so as to remove or disable such access to such illegal content. So 36 hours is what is the statutory time frame for you. So if tomorrow some notification comes to you that there's some illegal content, I will suggest don't wait for 36 hours. Remove it immediately. A lot of times some content you see and you say, well, that's illegal, that should not be there. Then don't even wait for someone to notify you about that. Just remove that. Why? Because that's healthy, good legal practice. It also ensures that you are going to be potentially protected legally, because this proactive removal will show that you've actually done proactive compliances. You've been very proactive in ensuring that your network or your computer platform is not unauthorizedly used for purposes of dissemination or publication or transmission of any content which is in contravention or violation of the law. Otherwise, please remove it within 36 hours once you're notified. If you don't remove that, then I think you're playing with fire. Why? Because then the law says that the affected person or even the concerned government entity can sue you in a court of law, can actually ask damages by way of compensation, and of course can also get an injunction against you. And a criminal action can also be initiated against you, because if you have not removed the content within 36 hours, the law will presume that you have not done due diligence, which means that you have actually abetted, aided in the commission of any illegal crime or an offence or an act. And that's so, the chances are that you could be arraigned as a co-accused in the criminal proceedings per se. Can you hire a forensic expert? Yes, by all stretch of imagination you can. Just ensure that your forensic expert is legally and technically qualified to do so. Also, he must be able to give you a forensic report, which if you want to go to court of law, you can actually use it. So get a proper legal report, otherwise it's well within your rights to go ahead and engage a cyber forensic guy for that stuff. Okay, I see one more question here, and the question is, I see that question again from Arinut underscore Robrando. Can we use contests of different interests and skills such as posting selfies, writing creative content to help people earn more money through a one-on-one challenge? By all stretch of imagination, yes. The only thing is, when you do so, you become an intermediary. So please ensure that your documented due diligence is done, the terms and conditions are crystal clear, you are on the right side of the law. And of course, when you are providing these contests, you are not doing any activity which is in violation of law for the time being first. So I think well within course you can do that. Well, it's almost going to be about an hour. We had said that we will be doing it in an hour. I'm just trying to see whether we have any other more questions that we would want to take with specifically. Yeah, here's a question from Srinivas underscore MD Office, who says how cyber law helps Trojan attacks to people who are victims. So I think I'm saying how law helps you if you're a victim of a Trojan attack. Clearly the law helps you, the law gives you, the cyber legal frameworks give you legal remedies. These are remedies of seeking damages by way of compensation. Look, when a Trojan attack takes place, somebody enters into your computer system without your permission and then goes ahead and does a variety of unwarranted activities in the form of the Trojan. That being so, that's introducing a computer contaminant into your network or your computer system. In that scenario, you can not only, if you know the identity of the person who sent you the Trojan attack, get criminal charges registered against the concerned person. In addition, if you know the identity of the concerned person, you could also seek damages by way of compensation. And under the Indian IT law, you can seek up to 5 crore rupees or 50 million Indian rupees as damages by way of compensation. So you have remedies if you are victims, and for that, getting these damages by way of compensation, you don't have to go to special, to normal courts. You'll have to go to special courts which are established under the IT Act. These are the adjudicating officer, and more significantly, you will have to ensure that once you present your particular action or your petition, you follow it properly, because the law says it will have to be completed and decision will have to be given within 6 to 9 months from the time you go ahead and apply for those damages. So I think we have distinct, positive, cogent, effective legal remedy available to you if you are a victim of a Trojan attack per se. Well, I'm seeing that we have actually covered by and large a variety of questions that were asked during the course of this webinar. So in conclusion, what I can actually say is that all your distinct questions have actually nothing been wake-up calls. These core questions have actually asked us to think and forced us to think, are our operations, our setups, our businesses compliant with the law? Especially with cyber law. Why? Because cyber law deals with everything pertaining to the legal format, pertaining to legal policy and regulatory issues concerning data, information, computers, computer systems, computer networks, computer resources, and communication devices. So therefore, if they are non-compliant, don't worry. There's an old Indian saying that, the time you wake up, that's the time you think the morning has begun. So even if today you've come to know about certain of these important cyber law tips for your business, no problem. At least you've come to know them today. Please implement them in your day-to-day activities, in your business setups. Please protect your data very carefully, because a lot of times people are wanting to target your data. There will be competition who would want to unauthorizedly access your data. There will be errant employees who would be working in your system, who would want to potentially copy your confidential data, your trade secrets, want to sell it, misuse it, or abuse it in any manner whatsoever. So therefore you will have to be very careful that your relevant activities are compliant with the cyber law. Given the huge ambit and scope in which the term intermediary has been defined under the Information Technology Act 2000, I am crystal clear that 9.5 out of 10 legal entities in India who do business become intermediaries. Because today almost anyone who does business is doing business using the electronic format, using email, using phones, using computers, using electronic data. That being so, your compliances as intermediaries become critical. Please ensure that you comply with the provisions of the law. If you comply with the same, to that extent, the Indian cyber law reminds me of an analogy. You know, in India, we have an ancient epic, the Mahabharata. In Mahabharata, Lord Krishna gave the Gita discourse. In the Gita discourse, it was categorically said by the Lord that if you come within the ambit of the Sharan or the protection of the Lord, then nothing evil will befall upon you, nothing bad can go against you. I think a similar analogy is what the law, the Indian cyber law is giving to you. Well, the Indian cyber law says, come within my Sharan, come within my ambit, comply with my terms and conditions, and I will ensure that no harm befalls upon you per se. So therefore, you will have to now shed your ignorance. You will have to ensure that you and your operations and your startups, your businesses, your companies must ensure documented compliance with the Indian cyber law. If you do so, then you are reasonably protected, because while you can still be sued, complaints can still be filed against you, no effective relief can be granted against you. So it's a kind of a statutory protection that the law gives you. I will encourage all of you who are working in your own startups, who are in the entrepreneurial businesses, or who are running companies, or who are running their own businesses or professional services, to ensure that if you are dealing with electronic format, please ensure compliance with the cyber law provisions. Ensure that you have the documents in place that you have complied with the law. Because tomorrow, if there's going to be a trouble, nobody is going to really be taking you on your face value. Nobody will believe your verbal version. They will look at documents. So your documents become critical. So ensure that your startups and your businesses are compliant with the laws, having in place the relevant documents that the Indian cyber law, the Indian IT law requires from you, and just go about doing things in a normal way. The law says, please don't stop doing business and start engaging with complying law. No, no, no. Your main job is to do business, is to do your work, your activity, your core competence. Please go ahead and do that. But while you're doing that, please ensure that you have done the due diligence that's expected out of a reasonable man. And what's the due diligence? The law says if you are a reasonable man of reasonable prudence, please ensure you comply with the law. Do not ignore the law. But if you ignore the law voluntarily or unconsciously, then you have to face the consequences for the same. And I can tell you, given my work in cyber law, that cyber law is a big whirlpool. Once you get stuck into cyber law, it can take you months, maybe years to get out of potential legal exposure and legal liability. So why do we want to even walk that particular walk? The better stuff will be that let's proactively ensure compliance with cyber law to the extent that the law is making provisions which impact your respective businesses, your respective activities, and then continue to keep on doing your respective works. And of course, in case tomorrow you find that you are a victim of cybercrime, please don't get silent. Don't suddenly think, I'm not going to report about it. Because today, if you're not going to report about the cybercrime, the cyber criminal is going to get far more emboldened. So take your due diligence. And if the cybercrime is targeted at your corporate entities, data, confidential data, or trade secrets, then make all the more sure that you report the matter per se. Only in being duly diligent, only in being compliant with the law, and only in being aware of the consequences of the law will be the way going forward. I'll very welcome any inputs, any questions that anyone that you would have. I think my numbers have already been, and my email IDs have already been put up on the chat here. Otherwise, I'm always available. It's a fascinating space. A lot of things are happening in cyber law. Please ensure that your operations as a startup, as a company, as a business, as a profession are compliant with the provisions of cyber law. Thanks. It's been lovely being with you on today's webinar. Hopefully you found this interesting, and we'll be happy to connect up with you in the coming times. Till then, take care. Bye-bye.